Welcome. Welcome back to the third and final session of the symposium today. My name is Patricia West, and I'm going to be the moderator for this panel. Unfortunately, I was not here for the first half of the day, but one of the panels was talking about the laws beginning to increase recognition of sexual autonomy rights. And as a result of that increased recognition, children may be treated as property, and that's going to be the discussion that our panelists lead us in today. I do have one announcement about the panel, and that is that Naomi Kohm, who was going to be here via Skype, is no longer able to be with us. She's ill, and I think we're having technical troubles with the Skype, and so for a variety of reasons, she is not going to be here today. However, we will have her remarks available, and I apologize to anyone who came specifically to hear her, but anyway, she cannot be with us today. But we still have a wonderful panel here today, and I'm going to introduce them, and then I will turn it over to them, and they will each get 12 to 15 minutes to make their opening comments. After that, we will take a short break, and we will come back after that and take questions from the audience. So formulate your questions as they're speaking, and we will get on with it then after they've had their opportunity to say their remarks. And then I'll let them comment on each other's remarks, too, after the break. All right. We first have, closest to me, Arina Grossu, who's the director for Center for Human Dignity. Arina is with the Family Research Council, Center for Human Dignity, where she focuses on the sanctity of human life issues ranging from conception to natural death. Her area of expertise includes abortion, women's health, conscious rights, bioethics, pornography, sex trafficking, assisted suicide, and euthanasia. Ms. Grossu is a graduate of the University of Notre Dame with a BA in philosophy and a minor in art history. She has received her MA in theology from the Dominican House Studies. Ms. Grossu also received a license in AMI Montessori through the Montessori Institute of San Diego. She is currently pursuing a certification in healthcare ethics through the National Catholic Bioethics Center. She is a currently on the board of directors for the National Pro-Life Religious Council, a current Leonine Fellow of the Catholic Information Center, and past president of Notre Dame Right for Life. Ms. Grossu is an alumna of the Vita Institute at the University of Notre Dame, which educates current and emerging national and international pro-life leaders. Close next to her is Ms. Lynne Marie Kohm. She is the John Brown McCarty Professor of Family Law at Regent University School of Law. She earned her law degree at Syracuse College of Law, and she graduated from Albany University. Professor Kohm has published prolifically on and in legal areas of concern to families, including marriage, women, children, families, trusts, and support obligations at death. She teaches family law, wills, trusts, and estates, elder law, bioethics, and gender in the law. Prior to teaching, Professor Kohm practiced law in New York, concentrating in the areas of estate planning, probate administration, real estate, and family law. She is licensed to practice law in Virginia, New York, Florida, and Massachusetts, and the District of Columbia. She's also a certified guardian ad litem. Lynne Marie has a missionary's heart, having served with full-time staff of Campus Crusade for Christ for 6 years prior to and during law school. She and her husband, Joe, have homeschooled their 2 children. And furthest away from me is Professor Jim Dwyer. He's professor of family law at the College of William and Mary. Professor Dwyer earned his law degree from Yale and his PhD in philosophy from Stanford. He has passionately and provocatively argued for a more child-centric legal regime, urging a myriad and aggressive changes to the current parent-centric thinking about child rearing. Before joining William and Mary, Professor Dwyer worked as a law guardian ad litem representing children in the New York State family courts. So we have a great panel with us today, and I'm looking forward to hearing their remarks. I will turn it over to them now, starting with Arina.
First of all, I want to just say thank you so much for having me here. It is an honor to be with you. This campus is so beautiful, and everyone I have met so far has been so kind and warm and welcoming, so I really appreciate it. Going off of the luncheon talk, and let's create a different narrative. And this also goes to another issue because children are being treated as property, and this is a result of the sexual exploitation that is going on culturally. And so I'm going to go through various situations where they are, and what I think a way out of this. So I would like to start by first saying that we should have some guiding principles, that children are not gifts. Children are gifts, they're not owed to us, and adults don't have a right to them. And I think that that's something in society that is not prevalent right now. And a child may be considered a piece of property or an object of ownership, but they are the fruit of a marital act between husband and wife, and they have a right to be respected as a person. They have the fullness of dignity, and they should be respected. And an adult's desire for a child does not give them the right to create one by whatever means necessary. And so how are children being treated like property today? Well, we have the precedent of Roe v. Wade in the abortion issue, that the right to privacy of the woman supersedes the unborn child's right to life. And so that's first and foremost, and that's based on the liberty language of the 14th Amendment. And the child is disposed of according to the woman's wishes. The child is not considered a person by the court. And this further went on with the Planned Parenthood versus Casey, where it said our law affords constitutional protection to personal decisions relating to marriage, procreation, contraception, family relations, child rearing, and education. These matters involving the most intimate and personal choices a person may make in a lifetime, choices central to personal dignity and autonomy, are central to the liberty protected by the 14th Amendment. Now we have to contrast this to how children are treated, how unborn children are treated outside of the abortion context. So for example, 38 states have fetal homicide laws that protect children if there was some kind of violence done to the woman and the parent. So the only exception is abortion, where that's the case, because in various other ways, in healthcare law, property law, and guardianship law, unborn children are treated as persons. Now, going into third-party reproduction, this is a huge area, and we'll see more and more of this as time passes, and as people struggling with infertility, as same-sex couples want to create their own children. We'll see this more and more. And so basically it's based on the freedom of a desiring party to create new life by whatever means they choose, and this is with very little or minimal regulation. And without regard for how the children are conceived, the possible separation from the biological parents, and the welfare after conception. Basically, especially in donor eggs and sperm, there's a reassignment of parental rights from the biological parents to the intending parents. And it leads to the manufacture of children, as we'll see with the surrogacy cases. And is this what's in the best interests of children, to be created in this way because of the desires of an adult to have children? And in the corollary, the desires of the adult not to have children, and we see that with Roe v. Wade. And this is a huge profit-making business. It's $6.5 billion business. And when we go into third-party reproduction, we see that the Supreme Court cases in decisions propose that the children should have a substantial long-term stability in their upbringing. And we see that with the sperm and egg donation, there's also a eugenics mindset that takes place, because the donors, first of all, have to relinquish their parental rights, but also the parents who choose, they choose based on certain kinds of qualities, characteristics. So it's a very buyer-seller type of relationship. And this puts children in a poor situation, because they have a right to know their biological origins, and each state and country have different laws regarding the exposure of this kind of information to children, and especially those who are created via a sperm or egg donation don't really have access to that information. And usually there are a lot of confusions on birth certificates in terms of whose name is on there. Is it the surrogate mother? Is it the intended parent? And so children don't really know where they come from anymore. And also this has led to disastrous consequences. For example, in the 1940s, Burton Weissner fathered up to 600 children, had his own fertility clinic, and impregnated women with his own sperm. There are cases where right now there's another sperm donor who has 150 children, and there's a problem with incest between half-siblings because usually donors are from the same area. So we don't see the ramifications of all of these technologies taking place. Also, a woman by the name of Wendy Kramer, the founder of the Donor Sibling Registry, made a point to say that these children should have access to know the half of their genetics, and they don't. And this is a tragedy because it's part of how we are created. There's a case in Buzanka in 1998 where JC had no legal parentage because she was made from a donor egg, donor sperm, surrogate parents, and also the intending couple split up. So she was declared by court having no legal parentage. And there are other cases, and I think we're going to touch on this with Craigslist sperm donor who is asked to provide child support because he delivered sperm in a cup instead of going through a medical facility. So now that couple split up and is asking for him to pay child support. So we have those kinds of cases, and also Mason and Breet, where a couple decided to have a child together, signed contracts, and now the wife doesn't want the biological father to have any kind of role in the son. And then in surrogacy is also another issue, and these are all combined because you have the donor eggs and sperm happen in the context of surrogacy and the context of IVF. And both women and children are objectified in this process. And again, surrogacy laws differ by state, by country. In the countries where it's where they're lax, that's where they're being most taken advantage of. So right now in India, it's a $400 million industry. In Thailand, it was just commercial surrogacy was banned because of a specific case with baby Gammy, who was commissioned by Australian parents, and they wanted, the surrogate mother from Thailand wanted to keep the twins. She had twins, and they found out that one of the twins had Down syndrome, so the intending parents wanted the child with the Down syndrome to be aborted, and she refused to abort the baby. She now is taking care of the baby, but Thailand, as a result, has banned commercial surrogacy. We have another case in Connecticut where another couple, lesbian couple, wanted to offer $10,000 to a woman to abort the surrogate child that she was carrying because, again, the child had abnormalities. And the surrogate mother went to Michigan because there she was considered the legal mother of the child, so she could escape and she could save the baby from being aborted, from being forced to abort the baby that she was carrying. There are other cases. Sherry Shepard, the former co-host of The View, she also hired a surrogate with her husband, and then they split, and now she wants nothing to do with the baby, and now the surrogate is left to handle that situation. And in Japan, there's a 24-year-old businessman who fathered 16 surrogate children and plans on having 10 to 15 children every single year by surrogate women. So we see the complex problems involved with surrogacy. These are just some of the cases. There are tons of them. And of course, like I said before, it's all through the process of IVF, which involves hormone treatment, involves invasive egg extraction, involves sperm collection via masturbation, the creation and implantation of multiple embryos. So then there's an abortion of embryos that they don't want, that don't look as healthy, or if the woman doesn't want a few children at once, they're aborted. And then the problem with the leftover frozen embryos. So right now there are over 800,000 frozen embryos living in limbo, and there are the states by states deal differently with these embryos, and they are the subject of some of the most interesting debates about whether children are property. And I actually want to go through some of those because I think that has been an area where they've spoken pretty clearly about children being treated as property. And basically, in these cases, the bottom line, because I've looked through a number of these cases, frozen embryos have been destroyed as the result of one genetic parent saying that they don't want implantation. So if one genetic parent says they want implantation, the other one says they don't, generally the courts have gone in the direction of the parent who does not want implantation based on the right to privacy. And so this has been one of the situations. And also, in a lot of these cases, they have called these embryos, who are babies, pre-zygotes, pre-embryos, tissue. They've used language that is dehumanizing of what the actual reality of those embryos are. So, for example, in one of the biggest ones is Davis versus Davis. They said that they're neither persons nor property, but they occupy an interim category that entitles them to special respect, and that they have potential for human life, and that the parents have an interest in the nature of ownership. And then basically it went on the side of the father who did not want them, saying that it would rob him of procreational autonomy. In Cass versus Cass, the legal ownership of any stored, the couple signed a contract saying that the legal ownership of any stored pre-zygotes must be determined in a property settlement. And then in AZ versus BZ, again, the court decided that forced procreation is not an area that they should be judicially enforced. And they're also treated, in a couple other cases, they're treated as property transferable by a contract. And then also in York versus Jones, the relationship they have with a fertility clinic is between a bailor and a bailee, so the one who places control of property into someone else's hands. And so there are a number of other cases. I won't have time to go through all of them right now. But this is another huge issue. How do we handle what happens to these frozen embryos that are real human living beings? Also, three-parent embryos. This is where the egg of a woman who has a defective mitochondria, the nucleus is taken out, put into an egg of another woman. So there are two DNAs, genetic DNAs of two different eggs, and they're inseminated by a sperm. And then you have extra-marital agreements. This is where you have lesbian and gay couples. One of them is the genetic parent, another one is not. If they divorce, if they separate, there are a lot of legal battles between them as to if the non-genetic parent can have any legal parentage in the life of the child. And then you have wrongful birth, where people are suing because the doctors did not tell them about a certain condition. There's a couple who won $50 million because they were not told of their child. They said they would have aborted the child had they known about it. So you have those kinds of cases. And you have issues as to what to do with, if it's extended, if basically marriage is not about a man and a woman coming together, well, why can't it be about pedophiles coming, marrying a young child? So we see the fallout of these combinations of families that are forming and the effect it has on children. So currently, there's an organization called Anonymous Us, where adult children who are created by these third-party reproductive technologies speak out about their experiences growing up in these abnormal type of situations. And then you also have adult children from same-sex unions who are speaking out, and they just filed a brief in the Fifth Circuit Court, and they're also filing a joint brief with the Supreme Court to tell about their experiences of growing up in these situations. So how do we get here? Basically, there's a tie between marriage, sex, and procreation, which has now been completely broken. And this has been in a vast scale by the use of and the passage of the pill in the 1960s, which led to the sexual revolution, which then led to abortion, and now to the identity dysfunction as to the roles between men and women and the role of procreation within marriage. So, a number of other points I wanted to make is that it's really tied to the marriage issue, and it can't be separated from. And the reason we're seeing all of this is because these abnormal situations and the families are creating, and they somehow want some kind of tie to biological children. So we cannot separate them from what's going on in the courts on the marriage issue. And so, but but actually Helen Alvarez wrote that this is a dramatic reversal to the Supreme Court's decisions in the last 120 years about the rights of children to be brought up by the parental unit, the biological parents, or parents who are, if they are not able to raise them, by parents who are fit, who can provide what the biological parents cannot provide. And so you have basically the disappearance of children from family law because it's tied to marriage, and if marriage is not tied to procreation anymore, it's contrary to the protection of children under the law. So basically, before pre-Windsor, is not adult-centric, and now it is adult-centric, and this has been our what we've seen in the past. So what is the best for human flourishing? And the best is a preference for married, two-person households and maintaining relationships with biological parents in the case where this is not possible. Our laws and Constitution mandate a strong preference for the relationship between the child and the natural parents. We have social science that reveals this. We see that children in these types of families have higher positive social development, higher quality of the parent-child relationship, whether it's through with the family with the biological parents or with an adopted family. And what's to be done? And I'm going to wrap up with this, is that first we have to focus on the rights of the child. I think the UN Convention on the Rights of the Child is right on. It was effective as of 1990, and portions of it can be implemented at the state and federal level, and parts of it are the right to have a name, the right to life, the right to nationality, the right to know and be cared by your parents, the right to preserve your own identity and family relations, and in the case where the parents cannot do this, that the judicial review will separate and do what's in the best interest of the child. And the second one, and I think that this is where we're going to hear more about this, is that it needs to be buttressed by the best interest framework, that it cannot be separated from, but that we first have to work on the rights of the child. And I was reading a really interesting article by Professor Kohm saying that the best interest of the child cannot start after conception, that we have to look at the best interest of the child before conception as well. And so the best interest of the argument has to be both ways. And so looking at this, the state has a vested interest in making sure that the parents are fit. So whether they do programs to make sure that they will be fit, so before conception, so that the law later, after birth, that they can be what the children need. And so that's the first look at best interest, so that we're not ending up in a situation where they are formed by IVF or other reproductive technologies. Is that really in the best interest of the children to begin with? And if not, those things should be prohibited, and that is the assertion. But then after birth, that we do need to look at what's in the best interest of children and to create a framework where we're seeing in what area and how are they going to thrive best. And so the bottom line is that the children do have a right to the parents, and if the parents are unable or unfit to take care of the children, that is where the law steps in and finds what's in the best interest of children. Thank you.
Hello, welcome everybody. It's an honor to be here. I really want to thank the Center for Global Justice for sponsoring this event, and especially Ernie Walton and all the work you've done, Ernie, and especially Lisa Marie Otto and all the work she's done. None of us would be here without them. That's right. Exactly. And thank you, Judge West, and all my panelists. I can tell we're going to have fun because Arina just laid out a great overview, but I disagree with about half of what she said. So this is going to be really fun. And you're all going, what? And actually, I want to thank all you alumni who are here. There's a ton of alumni here. It's very exciting. Thanks for being here. I really want to thank all of you students who are here. This is exciting. If you've already been through family law, you know half of what Arina said, so this is going to be exciting. And then I want to thank Sandra, Sandra, who's going to help me with my PowerPoint. She has drafted a PowerPoint for me while I'll be speaking my remarks. But I really want to thank Charlie and Fran Lewis. We would not be here without both of you. So thank you for your vision. Thank you for your support. We all are endeared to you. Thank you. Absolutely. So let's see if I can get comfortable here. So, are children property? Or are children individuals with liberty interests? The first panel today discussed sexual autonomy rights of adults creating children. Judge West reminded us of that already. This panel moves from there to the problems created for children by those adult rights. So the premise now seems to be that as the law increases recognition of sexual autonomy rights for adults, children are often seemingly treated as property. And I'm going to try to use my remarks to demonstrate this. So if the law really does treat children as property, do we solve that problem by granting children's rights, like Arina just mentioned? Is that how we solve it? Or do we solve it by giving parents additional rights and duties to protect their children? Or should the state step in to protect children when parents do not? My remarks today will offer a solution in suggesting that children do have a liberty interest in having a relationship with both the mother and a father, and those parents have duties to protect the child's interests that can be enforced by the state for the child. So a good way to begin this discussion is to make some distinctions. I'd like to explain what a children's rights framework really is. We went a little too fast. You're having too much fun, Sandra. So let me start by trying to explain to you the difference between children's rights and a best interests. So a children's rights framework starts with this triangle. Picture the children on the top, children's interests at the top, parental rights at the bottom left, and then state's interests at the bottom right. This provides an illustration of how children's rights can be contemplated. The child has a right as against the parent, and as against the state. And all three actors, parent, state, and child, can pursue their rights against one another. So you have a triangle that's continually in tension. This is a picture of a children's rights framework, and this is the rights structure adopted by the international community with the Convention on the Rights of the Child, adopted by 192 nations. Conversely, a best interest framework is used in every state family court in the United States. The structure sets up the best interest of the child as the objective is accomplished by both the parent and the state for what's best for the child. The best interest of the child is the highest duty of a parent. And when the parent ceases to protect those best interests, the state can step in as parens patriae, or state as parent, and do what the parent should have done. So parental rights granted as fundamental and constitutionally protected are balanced by parental duties, as you can see in the diagram. And those parental rights and duties are not, especially the parental rights, are not unlimited. And the case law has made that clear as well. They can be abridged by the state when the parent ceases to act in the best interest of the child, so that the state may intervene to protect and provide for the child in their stead. So I have written about these positions before, and I've also discussed the problem of children's rights, and I'm going to try to balance them both in my remarks today. And these are really two very didactic perspectives, children's rights versus children's best interests. And they're helpful in answering some questions that we're dealing with today, whether children are property or they're people that should have rights. One looks at children as rights holders and independent actors, the children's rights framework. The other one perceives children as legally incapacitated, deserving of protection and provision from adults. Some recent cases can help us to discern the difference between these two frameworks and how they play out legally and pragmatically. So let's look at some of these cases. The first one is in the European Court of Human Rights right now. It's a case called Perillo v. Italy. And that case is, the court is trying to determine whether Italy's law criminalizing the destruction of human embryos abridges the parental interest in those embryos. Assisted reproductive technology can access sperm and eggs and unite them to form an embryo, which once gestated by a woman has the opportunity to become a child. Biological life begins at the moment of conception or the forming of the embryo, though many challenge whether human rights attach at that point. Mrs. Perillo argues that the embryos she and her now late husband created are her property, And now, in his demise, she no longer wants to gestate those embryos or give them a chance for life, but she wants to allow them to be used for research, ensuring their destruction. And I don't think people realize that. When you give embryos to research, they are not going to live. They will die. They will be dissected and destroyed. So research means destruction of the embryonic child. She argues that she's being denied her property rights and, quote, her right to private life by Italy. Italy argues, however, that it has a duty to protect those embryos from destruction. The European Center for Law and Justice, connected with our American Center for Law and Justice, has submitted an amicus brief, and they argue there that destruction of the embryos under the European Convention on Human Rights can only be allowed to protect the life and health of the mother, something not even at issue here because the embryos are frozen. Perillo makes the my child, my property argument, while Italy essentially makes a best interest of the child argument on behalf of the frozen embryos. The case was heard in June of 2014, so more than 8 months ago, but there has been no ruling handed down to date, so just keep your eyes out for that one. Another illustrative example is one that Arina already mentioned. The difference between these two positions can be clearly seen in the Craigslist sperm donor case. Two women in a lesbian relationship agreed together to conceive a child, and they found a sperm donor on Craigslist. Isn't that where you'd go? Anyway, that's where they went. And the man contracted with them to privately deliver his sperm to them for their at-home use in assisted procreation. None of the parties sought legal advice, and that is the worst thing you can do, right, students? Duh, get a lawyer. Anyway, none of them sought a lawyer, but they all signed an apparently internet downloaded sample contract, which means lots more money for lawyers because that's the most foolish way to protect your rights. Anyway, they downloaded this contract, they sealed their intentions to protect the sperm donor from any rights or obligations to the child, but none of them knew what Kansas code required. The Kansas Code provides statutorily for the termination of a male donor's duty to child support when sperm donation and assisted conception occur under the supervision of a licensed physician. A missing element in these facts. He delivered the sperm to their front door and they used it and conceived a child. When a year after the child was born and the two women split up, the birth mother sought public benefits for her child through the Kansas Department of Children and Families, who in turn sought to obtain child support from the sperm donor, the father. The rights and duties of the exited lesbian partner were reserved for another action, so the case I'm talking about doesn't mention that. But the court's ruling in the case of Kansas versus WM held that a man's status as that of a sperm donor or birth father, even in the face of a written non-paternity agreement, when his semen was used as an artificial insemination procedure that resulted in a live birth, but was not provided to a licensed physician, was indeed subject to rights and responsibilities of parenthood. So because they didn't use a doctor, they all have to pay for the support of the child. His rights especially were not terminated. This is a very strong point to illustrate the best interest of the child. When we create life, that life is not property. The court considered the child's best interest more than the man's property interest in his sperm. You can deliver property as you wish, you can transfer title, but once life enters the picture, it cannot be treated in the same manner as property. In other words, the best interest of the child standard governed the actions of the parents and the state in providing support to the child. While the child's existence was apparently more analogous to a property interest by the parents exercising their sexual autonomy via Craigslist. So let me give you another example. Consider the 21st century phenomenon of designer babies. Arina also mentioned this a little bit. Rapid progress in genetics and reproductive technology is making more likely the process of adults being able to design and pursue their own global baby making. The BBC reported this. They said there's so much progress in this area, there really needs to be a public debate because the ability to genetically modify people can tend to treat human beings, particularly children, as property. Using technology to create better health for a child could also be seen, however, as a process whereby parents could use to further the child's best interests, making the child healthy. Along these lines, the UK government has supported the creation of babies using DNA from 3 people to eliminate debilitating and potentially fatal mitochondrial diseases that are passed on from mother to child by using healthy donor eggs and to prevent diseases for the child. This is both excellent news for families with mitochondrial disease, while also reiterating the sexual autonomy of the adults involved. Experts say this will offer women who carry disease genes more reproductive choice. Children who result, however, according to UK proposed legislation, would have no right to know the identity of their egg donor. In other words, they would never know their mother, one of their mothers. And the embryo destroyed in the process is a byproduct of the procedure. This presents the process as one where children are viewed as property by their parents, and a notion fostered by state regulation now in the UK. And right now it's only available there. Children who result, however, according to the UK legislation, have no rights there. Children do have rights in the UK. The UK is a nation that has signed the Convention on the Rights of the Child, but they do not enjoy them until they're born. And even then, those rights are often at the mercy of the adult who advocates for the child's right. Another view of this designer baby phenomenon is available from a new mother who writes in the New York Times, and I'm quoting her, "I chose my son by clicking and unclicking a series of boxes, not unlike online dating. One of them looked like Tom Brady and had a PhD. I added him to my cart. As it turns out, I didn't just add my son Leo to my cart. He came with 14 brothers and sisters, at least 14 brothers and sisters. There are likely more that we don't even know about, from my egg donation, the sperm donor's natural children, unregistered siblings, and some of who haven't been born yet." So you add your son to your cart like you're shopping at Walmart. That's certainly treating children like property. Professor Kohm, who would have joined us, but she has the flu and we can't get the Skype to work, she has done extensive work on donor sibling registry, something Arina also mentioned. But her work will be well worth reading when it comes out in the journal. You'll want to get that. Even in last weekend's paper, in the Dear Abby column, Abby was offering advice about someone who didn't want to see other people's ultrasound pictures of their child. And she said, new parents viewing their children on a sonogram was good for them to, quote, be able to see the product they're manufacturing pre-delivery. As a mom, I lost my stomach. I'm like, dear Abby, how could you disappoint me so much? As a product manufacturing pre-delivery. We're treating children as property. Finally, the public policy over pedophilia may come into play when discussing children's rights or children's best interests. It seems logical that if a child is viewed as property, then they can also be treated as sexual objects as well. In fact, the legalization of pedophilia is already clear in some parts of the world. For example, in Iraq, a girl can get married at age 9. Furthermore, when pedophilia is considered through the lens of sexual orientation, adults can argue that children should be viewed as sexual beings, as those who have the right to express their sexuality, to select their own orientation. Perceiving children as sexual beings is advanced by a children's rights perspective. This, in turn, advances the view that children have the right to consent to sex, and to consent to sex with adults, submitting their innocence to numerous things that adults may suggest to them. This line of thinking can be developed in a sex education class in that process as part of a child's right. On the other hand, a best interest approach would work to allow parents and the state, if parents abrogate that duty, to protect the child from sexual manipulation by any adult. So how far should sexual autonomy go? It's the question we have to ask ourselves. Does the framework for children's rights advance the thinking of children as a commodity? And if so, why? And if it does, if it does so because children are left to protect their own rights. Imagine a 9-year-old protecting her own rights to marry or not to marry, or a 4-year-old protecting his or her own rights to consent to sex. You can't imagine it because children are incapacitated. They have no one to advance those rights for them but adults upon whom they most rely, while removing the protections offered to the children under the best interest framework. A better solution, I argue, is to apply a best interest framework for a child's protection and provision. And one Virginia example illustrates this position in the form of a child's liberty interest, something different than a right. In fact, the Center for Global Justice, Human Rights, and the Rule of Law, the sponsor of this event, was at the forefront of this debate when it filed an amicus brief in August of 2012 on behalf of the best interest of a child caught in the middle of her parents' assisted reproduction parentage dispute. That brief became the basis for the Supreme Court of Virginia's decision in 2013 to find that children have a liberty interest in knowing their parents. In the case of LF v. Mason v. Bright, the Supreme Court of Virginia was asked to intervene when a mother wished to legally remove a father from the child's life. She labeled him a sperm donor because they were unmarried. The Center for Global Justice participated in that litigation on behalf of the child with an amicus brief, arguing that a child should not be deprived of a parent when one parent claimed that the other parent was merely a sperm donor rather than an intended parent, despite the existence of the parties' jointly signed paternity agreement. Under a children's rights framework, the court would consider the rights of the adult parties as against the child's rights. How would a court determine which rights are superior, the mother's rights or the father's rights or the child's rights? Instead, a best interest of the child approach protects the child from the poor choices a parent might legally make under a children's rights framework. Children resulting from assisted reproductive techniques are extremely vulnerable, just as the embryos in the Perillo case, the child resulting from the Craigslist transaction. Imagine growing up knowing that you were the subject matter of that case, or the embryos used in the designer babies. These children absolutely require their parents to protect their interests, even when their parents are seemingly simply exercising their own sexual autonomy. When that required child protection doesn't happen, the child can be irreparably harmed. In the Virginia case, we saw an opportunity for a child to be deprived forever of one of her intended parents by the other parent, something that cannot be in a child's best interest. Our brief focused on the injustice in that scenario for any child, arguing that a child has an interest in knowing her parents that should be protected by federal constitutional law, Virginia law, and good public policy on families. The court adopted concepts set forth in our brief verbatim. We were shocked. We were very excited. And they particularly took our language regarding the best interest of the child, resting on the opportunity to have both a father and a mother involved in her life, and the duty of the state to protect those interests when the parents do not. Let me read you an excerpt from the court's opinion describing their rationale. They say, "We reject the notion that children have a purported right or interest in not having a father. To the contrary, Virginia case law makes clear that it is in a child's best interest to have the support and involvement of both a mother and a father, even if they are unmarried, recognizing that one parent cannot arbitrarily deprive a child of a relationship with the other parent. Although our analysis in this case rests on Bright's constitutionally protected rights as a parent," the court continues, "we recognize that children also have a liberty interest in establishing relationships with their parents. Consequently, it's incumbent on courts to see that the best interests of a child prevail, particularly when one parent intends to deprive the child of a relationship with the other. Here," the court writes, "LF faces a potential loss of liberty in the form of a deprivation of a relationship with her biological father, solely because she was conceived through assisted conception by unmarried parents. Virginia's marital preference, which is a good thing, in assisted conception protects an intact family from intervention by third-party strangers, but it is not intended to deprive a child of a responsible, involved parent." End of what the court said. This case is really significant because it was the first time that any court recognized that a child has a liberty interest in knowing and having a relationship with their parents. So it took a child's view, a child's perspective. It is particularly important because that interest is recognized not in a rights framework, but in a best interest framework, and the court kept echoing that. The work of this brief by the Center for Global Justice was done by students and faculty together as part of the Child Advocacy Practicum, a curricular arm of the Center for Global Justice. The center brief made a tremendous difference in the life of that one little child, LF, restoring her to her father as well as to her mother, constitutionally guaranteeing her both parents based on her liberty interest. It will also work to protect other children from being deprived of a parent, and all resting on the best interest of the child framework. That ruling also illustrates the effectiveness of the state's duty and the parent's duty to accomplish the best interests of the child in the form of a child's liberty interest in that case, rather than to uphold some sort of right by the child. Rather, it enforced the duties of the state and the parent for what was best for the child. This is important because it reveals the best way to protect children is with their best interest framework rather than a rights framework. So, why is a liberty interest not a right? because it works to require the duties of one set of people, here adults, to protect another set of people, here children, rather than allowing adult sexual autonomy to run wild and rampant, really, over children's lives. In 1967, the Supreme Court of the United States in In re Galt found that children are not beyond the protection of the Constitution, while the court also recognized the state's power to make adjustments in the constitutional interests of minors, which flow from the state's concern with the unique position of minors. Indeed, in Bellotti v. Baird, a 1979 case on parental notification of a child's use of contraception, the court held that the importance of the parental role in child rearing, while also noting that the constitutional rights of children cannot be equated with those of adults due to, quote, the peculiar vulnerability of children, something we all know. The state has a rationally related legitimate interest in a child's welfare and best interests. A best interest approach accomplishes what a rights approach cannot. So to conclude, children ought never to be perceived or used as property, and rights do not protect them from that end. Rather, rights can tend to advance the notion of children as property. Indeed, who protects the rights of a child when those rights are pitted against the parent's interests and against the state's interests? When sexual autonomy rights of adults in procreating children create conflicting scenarios for the resulting children, those problems are not well solved by a children's rights framework. Rather, as the law increases recognition of sexual autonomy rights for adults, children are seemingly treated as property. The solution is to proffer that children have a liberty interest in having a relationship with both a mother and a father. And those parents have duties to protect the child's interests, particularly when exercising their own sexual autonomy, which, when parents do not act accordingly, the state can intervene for the best interests of the child. And if you heard me say anything, you heard best interests of the child, right? Thank you very much.
Hello. Thank you for being here to share in this conversation. This is my second occasion speaking at Regent. The last time was about a dozen years ago. And again, it's been an extraordinary experience, both because of the welcome, and you know, anywhere you go, they're going to welcome you if they've invited you. But there's a warmth to the welcome here that is really rare. And the Lewises were actually a big part of that, welcoming all of the speakers here. We're grateful for that. It's also been extraordinary because of this stimulating and challenging nature of discussions. They're generally here of a type that I don't hear elsewhere in a very positive way. And so my notes are a mess because I spent the whole morning just scratching ideas that were coming to me as people spoke. And I'd like you to pretend that that's the reason why I'm not as eloquent as the other speakers. My notes are a mess. So, okay. So we're going to talk about property, and law students learn quickly that this is an amorphous concept. I think the sense intended here is a thing not accorded the moral status of a person. Moral status is the place that an entity occupies in a hierarchy of beings, determining whether and to what extent the entity deserves moral regard. And moral regard means receiving consideration for one's interests and dignity in the decision-making of moral agents. All right, so a little bit of definitional business there. So I understand the question to be here, are there law and policy contexts in which we moral agents, directly or through the state as our agent, and it's important always to keep in mind that in a democracy, at least in theory, the state is an agent for the collective will that we participate in creating, right? So we share responsibility for what the state does. Does the state or people treat human beings that are less than 18 years of age as undeserving of the sort of respect for their own interests and integrity that we generally accord to human beings over the age of 18 years, or perhaps more tellingly, of the sort that we expect for ourselves? Do we treat them instead, explicitly or implicitly, the way we treat non-human entities like automobiles, with respect to which we might have moral duties, but not owed to them, but rather to whoever owns them? And the answer to the question, I think, is undeniably yes, and the only real debate, I think, is potentially in which context that occurs, and I'm not sure we're going to have an awful lot of disagreement about that on this panel. In all of these ways, I think, even if they're not directly about exploitation, or sexuality contribute to an attitude toward children that I think makes them vulnerable to exploitation, and in particular in a sexual way. So starting with before birth, I think Arina is certainly right that this occurs in the context of abortion, that we treat human life as property. Some philosophers have argued that abortion rights can be defended even on the assumption that a fetus is a person with a moral status equal to that of humans after birth. But I think those arguments are generally regarded as unconvincing as to pregnancies that result from voluntary conduct. And that might be the reason why in court decisions and in public discourse in favor of abortion rights, you generally see unborn children treated, at least before the point of viability, as categorically different from humans after birth in their moral status, and in fact as mere things, disposable at will, having no moral claims on us. Is that wrong? How could we demonstrate otherwise? Well, in a book I published a few years ago with Cambridge called Moral Status in Human Life, I undertook a thorough analysis of what entities we should regard as having moral status, as a matter of rational consistency. And I showed the falsity of a common assumption that higher cognitive capacities are the only human attribute that give rise to moral status. And in fact, I think no one actually adheres to that assumption consistently, or else we would endorse treating severely mentally disabled adults, the elderly when they lose their capacities, and even ourselves when we're sleeping or if we fall into a coma as property, possessing no moral rights, owed no moral consideration. In fact, our moral psychology and moral practices reflect several bases for ascribing moral status, including not only current possession of rational capacities, but also the potential for becoming autonomous, sentience, and even mere aliveness. And so although the book is mostly about children after birth, I do note that a complete account of moral status must accord some to unborn human life. And I think it's telling that people who conceive a child and want to have the baby tend to treat the child before birth very early, as soon as they know of its existence, very much like they will after its birth, right? They say, here's a person, here is our child. They have names, they talk to the child, and so forth. I think that's very indicative. So my account of moral status leaves open the theoretical possibility that moral status can vary for human beings. It's not necessarily an all or nothing thing, so possibly an early stage fetus could have less, and it would develop over time. I didn't really work that out. It's just a theoretical possibility I left open. But I think my account does show it to be indefensible to claim that a fetus is morally indistinguishable from a chair, right, that is subject to use or destruction as its owner wishes to the same extent. And it can't be that the pregnant woman's attitude toward the fetus, wanting it or not wanting it, changes its moral status, right? My attitude toward my neighbor doesn't change my neighbor's moral status, right? I don't think that simply because the woman doesn't want to have the baby that it becomes a thing. And yet, treating early human lives who are unwanted as mere things serves certain purposes for some people, right? Obviously, it makes it easier for mothers to pursue other aims in life, and it lowers the moral costs of sex for pleasure, right? And so in that sense, it does fairly directly support the sexualization of culture. Now we'll move on to children after birth. I think that treatment of young humans as property is not confined to the pre-birth period. Just after their birth, the state places newborn children into legal relationships with adults in such a way that pays no regard whatsoever for the children's welfare. It does so based on rules that did not develop based on any assumptions about children's interests, but rather based on an assumed Lockean-type property right of biological parents to ownership, including possession, of what they have created. So no state's laws today allow for denial of legal parent status to a biological parent on the grounds that he or she has clearly manifested abject unfitness for parenthood. At best, the state will withhold possession for a time, and place the child in a relationship limbo that is likely to have lifelong adverse consequences. If you know about the importance of attachment in the first couple years of life and what a temporary status without a permanent and consistent nurturing caregiver can do to a child, you should learn about that. More likely, the state will also repose possession and plenary power in the abjectly unfit parents, and so cause the child even worse lifelong damaging effects. Effects that will manifest in the kinds of sick behavior that we've been talking about today, right? So if you examine the past of traffickers and their customers, of rapists, sex predators, and prostitutes, you're likely to find the childhood in which these persons were damaged. And if you want to attack the demand side of sexual exploitation, I think you have to look at reforming parentage laws to at least identify and spare children from being put in the custody of parents who are utterly incapable of caring for them. Likewise inconsistent with the way that the law shows respect to adults, autonomous or not, and this is going to be, I think, harder to acknowledge, it's perhaps less well recognized, is the doctrine of parental control rights that the Supreme Court created in the 1920s. It treats children alone, among all categories of human beings, as objects of others' rights, as beings whose lives, for many years after birth, are viewed as belonging not to them, but to certain adults, that is, those on whom the state has conferred legal status and possession. The adult, not the child, bears an entitlement regarding how the child's life goes. And this is illustrated, I think, by the common use of the term parental autonomy, the way that this amounts to eluding the personhood of child. Autonomy, means self-determination, and parenting is decidedly not that, right? If you assume that child is a separate person in his or her own right, parental autonomy is effectively a denial of that. So I think this too, this notion of parental entitlement over children's lives, contributes to thinking about children, not only by strangers, but also by parents themselves, as things rather than persons, as beings who are less worthy of moral concern and respectful treatment. And note that much sexual predation is inflicted by parents and traditional families, right? This is not all done by strangers to the family or to the child. If you contrast the way we conceptualize the parent-child relationship with the law governing custody and management of incompetent adults, right, guardianship, it treats the guardian role as a fiduciary one, devoid of rights, so that a guardian who disagrees with some state-imposed duty must object based on the ward's rights and the ward's welfare, the content of which is not dictated by the guardian as a matter of entitlement. And neither the ward's rights or welfare must be balanced against any rights or interests of the guardian. So that's the model we have for morally respectful treatment of persons who lack autonomy. It replicates the rights of autonomous adults as closely as possible, right? Simply substituting for self-determining choices the judgment of a fiduciary for making choices for someone who can't do it for themselves. And I think this fosters in guardians a very different kind of attitude, a disposition to act with care rather than indifference, to be other-regarding rather than self-regarding, to be thoughtful rather than impulsive. A final set of examples shows that children are treated as property not only of individuals, of parents, but also of communities and of nations by domestic and international law. So, for example, the Indian Child Welfare Act treats children as a tribal resource. This is explicit in the federal statute. And its effect today is largely to cause children, most of whom have never lived in a Native American community, nearly all of whom have very little Native American ancestry, to be separated from loving adoptive caregivers. In the international realm, international law relating to adoption, to transnational adoption, is being interpreted as justification for shutting it down, for shutting down international adoption, trapping children in institutional custody, increasing the likelihood that they will end up being trafficked, depriving them of the crucial good of a family that could provide many healthy options in life, and the personal well-being that would enable a child, once grown, to choose healthy options instead of sick options. But because children are viewed as the property of the government where they were born, and therefore properly subject to the whims of the leaders at the time, who are more concerned about national pride than about what is best for parentless children, they remain imprisoned in institutions, in orphanages, or living on streets. So what is the remedy? What I've begun to argue, to urge as a remedy for this collective tendency to view children as property, whether of parents or of a community, a nation, of whoever wants to buy them, is to stop talking about rights pertaining to specific roles that people occupy in life, like parent or child. So I'm trying not to talk about children's rights anymore, but instead to talk about the rights of persons, of human beings, at any stage of life, and perhaps at the earliest stages of life. So we should speak about people as generically as possible in the first instance, and then qualify the rights that we ascribe to people in general only as necessary to accommodate their special circumstances and needs. By generalizing our normative characterization and justification for rights as much as possible, we might eliminate illicit preconceptions about the proper place of young persons, which should in turn minimize sui generis pseudo-reasoning that masquerades as justification for perpetuating their maltreatment. And it should also undermine the view of children as things available for use, for exploitation. So for example, with respect to family formation, this is the greatest determinant of a new person's life course and well-being, right? Whose custody you are in. So we should think first in the abstract about what rights persons in general should have to form a relationship of any kind with someone who would be good for them, or to avoid a relationship with someone that would be bad for them. One good candidate for a right of persons in general, I think, is a right against the state's forcing a person to be in any kind of relationship, especially any kind of family relationship and shared residence with someone whom the state knows is likely seriously to harm them. Once we've agreed on that, we should ask, is there any reason to exclude any particular group of persons from that right? Is there any human characteristic or circumstance that could make some persons undeserving of this right or unable to benefit from it? I cannot fathom what that could be. And in fact, I think we would endorse a stronger right, at least in theory. We would say that persons actually have a right against the states forcing them to be in a relationship with someone who is simply not the best available person for the relationship, right? As a theoretical matter, questions of operationalizing that right would come in later. What about persons who lack capacity for self-determining choices? As to them, we should simply ask, what's the best alternative way of realizing this right for them? And our actual practice regarding family formation for non-autonomous persons over the age of 18 and for non-autonomous persons who were recently born but whose biological parents can't take care of them, i.e. Children available for adoption, suggests an answer. For both, the law designates a state agency, namely a court, to act as an agent for the person, a proxy, a fiduciary, and to choose for that person from among those who express interests, the candidate who, all things considered, would be the best caretaker for that person, on the assumption this best approximates the paradigm case of self-determining and self-regarding choice by an autonomous person. We apply a rule of thumb. We have presumptions about who is best to fill that role, and that makes sense, right? So with parentage, biology makes sense as a presumption. But the preference or presumption is subject to override based on the overarching best interest standard. The last thing I want to suggest is that parents also might benefit from a reconceptualization of their role. The flip side of children being property is that someone owns them. right? And so if we think of children as parents' property, that means parents are owners. I don't think it ennobles me to be treated as the owner of my children. It doesn't suggest any kind of deservingness, any qualification, any virtues on my part. And if the state accords deference to my preferences as to how my children's lives go, I don't want it to be because they view me as entitled to that, regardless of whether it is actually good for my children, regardless of whether I can present child-centered reasons that they can understand. That would just make me feel like a bully. So granted, it's easier for me to say that than for many other people because my worldview is largely consistent with that of a modern liberal state. So my disagreement, for example, with the state on education policy is mostly about means rather than ends. But even if I had a very different worldview from the state in which I lived, by which I mean, the majority of people who create the laws, at least in theory, I would regard it as at best unfortunate that in order to get my way, I have to plant a flag and say, this is my territory, I own these children, not you. The denigration of my children that this would entail would make me feel diminished as well. I prefer to think of my parental role as a great privilege that I try to earn every day, that I should carry out with some humility regarding my own knowledge, and some appreciation that others might also have genuine concern for my children's welfare, might have a different perspective that I should at least consider. I get that here. Recognizing that it's probably not good for any dependent person for their custodian to have monopoly power over their lives. Thank you.
I want to thank the panel for their thought-provoking remarks. We have a lot to think about while we take a short 5-minute break. I'm going to ask them to comment on each other's remarks when we get back, and then we'll be taking questions.
Their own rights, but we know the inalienable rights that they have. So that's my first point. The second point is, I think the best interest framework works really well in the traditional setting of having biological parents deciding who would be the best parent in a divorce case, things like that, where the child would flourish best. I think there are limitations with the best interest framework in this complication we have, where we have multiple parents involved, whether it's because of the donors, it's because of the intended parents, it's the surrogate, the birth mother. And so when you're looking at the best interests of the child, when you have multiple adults involved, it gets really complicated. And for example, in the cases where people were, where a divorced couple was fighting over the frozen embryos, the trial courts went in favor of the best interest of the child to be implanted, but then those were overturned at the state court level, and they were not implanted. So the best interests of the child were not protected in that. And so you see how the best interest doesn't work in all cases. Another example is, we'll see more and more in the decisions concerning same-sex marriage cases, it's assumed that the children in those households, that their best interest is to remain in those households. And that's what the courts have assumed. They've kind of ignored the fact that maybe that's not in the best interest of children to be in the presence of one parent and one non-biological parent of the same sex. And so when you just leave it to best interest without the guidance of the fact that the right of a human being is to be originally brought up in an environment where they are brought up and created in a marital act between one man, one woman, and are raised by that couple unless the parents are not fit. And so out of that, without having that framework as a basis, it's very difficult to protect children from situations like that. And then also, best interest has not worked in cases of surrogacy, because you have surrogate mothers who have no biological connection to the child, and they might actually have the best interest of the child in mind, especially in those cases where the intending parents wanted to abort the child. And the best interest of the child is obviously human right to life. The child is already created. The child has a right to life. But in cases where, in those kinds of cases, it generally goes in the direction of the intended parents because the sperm and egg donors relinquish their parental rights. And so I think it gets very complicated. I think the best combination is to use the framework of the rights of persons as a whole, as human beings, for protecting the rights of persons, but then buttressing it with as Lynne was saying, best interests when it comes into that. I think it's just going to get more complicated as we see cases coming up.
Okay. I would just pose a question for the other two panelists, whether there is something good about assisted reproduction in light of the theme of the conference. So the usual way that children are created is by sexual acts, which may not be intended to create a child, but do, and then the child might be sort of wanted or accepted, and but perhaps treated with indifference by many parents. So that's one model, and on the other you have people who are extremely thoughtful about creating a child, do it without having sex, right? So it seems like the opposite of sexualization taking over family life, and perhaps even choosing the child's attributes that would seem to suggest the child even more wanted and valued than a child who's just accepted because we didn't have any choice. So just other sort of competing aspects of the practice of assisted reproduction that suggest it's not all bad.
How interesting, sexual autonomy without sex. That's what you're saying. Because there's no sex act, but there's sexual autonomy because we're procreating. So that's very interesting. I didn't think of it like that. I have some just basic remarks. I too like Jim's status of moral status as a human life, but I'm really kind of surprised to hear you say you love rights so much, because there's a reason why the United States has not signed the Convention on the Rights of the Child. Every other nation has, except us, because every single family court must and is charged with the duty to protect the best interests of the child. Not the rights of the child, not the rights of the parent, but when a child is the center, the court must determine what's best for the child. Now, the problem with that is best. Who knows what best means? It's subjective. At the same time, someone has to decide. Somehow, God decided when they became parents, but if they turn out to be not so good parents, courts can step in. Remember, that's the balance of the best interests. So my biggest problem with our discussion today is we keep talking about rights. Rights don't work. What work is duties. And that's my other problem with human rights in general. We always hear about human rights, human rights, human rights. If we all practiced human duties, we'd have no problems with human rights, wouldn't we? If parents practiced parental duties, we wouldn't have these autonomous parents going crazy. We would have parents that understood that the respect for their children is shown by providing duties to them that provide for their best. There are some interesting things that Jim said, too, about ICWA, the Indian Child Welfare Act, that it's retaining a child for a tribe, and I think you likened it to the international adoption field kind of shutting down. I think that's a really interesting analogy that we have to think about. The Indian Child Welfare Act was established because we ran roughshod over Native Americans, and we did destroy their civilization. And that's an effort to try to rebuild American Indian families. Are we doing the same internationally? I can see some who would argue that. At the same time, I think there's a different comparison. We haven't roughshod anybody like we did Native Americans. So there's a little bit different thing going on there. But I just want to mention that really what's happening here is an imbalance, an overemphasis on rights, when really what we need to be accomplishing is a protection of people with duties, with human duties. How much could we solve if we understood we have duties to people? Instead, we talk about rights without the context of duties. So if you do anything when you leave today, think about that. What duties do I have? The golden rule, treat your neighbor as yourself. Love your neighbor as yourself. It's a duty. It's not a right you have to be treated well. It's a duty you have to treat your neighbor well. Parents, we have duties to do what's best for our kid, not because we're entitled to it, not because we own them, but because they're a human being created by God. And we just get the trust we just get them entrusted to us, kind of like the fiduciary stuff you were talking about. So I guess I want to challenge everybody thinking about this issue. When we talk about rights, we are going to end up with sexual autonomy. But when we talk about duties, we're going to end up with moral status that protects human life.
Thank you, Pamela. Thank you very much. And I want to encourage anyone who wants to stay, and Ernie's going to come up and take questions from the audience. But for those who have to go, this is the official ending time. But we encourage you to stay. They're going to be here for a few minutes and answer your questions. So thank you. It's very nice meeting you, and thank you to Grossu. See you.
Teach that class.
I'm just waiting for everyone to clear out. Trying to give the Lewises a chance to clear out. Okay, I believe we have a question in the back, starting on Tim, if you want to go ahead and state your question.
Hi, thank you. I'm Tim, I'm a third-year law student here. And my question is regarding education. In looking towards the future, someday I hope to be a parent. And when I think about that, I want to raise my children within the Western tradition of education. I'd love for them to learn Latin, read the classics, and things like that. And so in thinking about that, I think probably my best options are probably a Jesuit education or some other form of private education, classical education. But if I don't live in a community that has that to offer, possibly home educating. And I know that some of the laws that have defended home education currently are based on what you were talking about, Professor Dwyer, in the 1920s and that kind of stuff, the rights of the parent. And so I was wondering if there is maybe is it better to think of it as maybe a duty of the parent? So I'm having a hard time getting to the question mark on that. But your thoughts on how to think about what's the best way to go about that of getting children educated in what I would think is the best interest, but I realize that maybe there are those out in society who don't necessarily think that's the best interest of the child. So then what would be the best way to advocate for me having the opportunity to have my children raised that way? Thank you.
Since Jim has more kids, he should definitely answer.
Yes, I'm co-authoring a book now on homeschooling, history and philosophy of it. I'm doing the philosophy part. As a practical matter, you don't need to do much of anything to make that happen. In Virginia, you can just tell the local school board that for religious reasons you want to homeschool your child, and that's the end of it. They're not allowed to talk to you again. And this is because state officials have gone far beyond what the Supreme Court has said parents are entitled to. They think that parents' rights are so extensive and absolute that they can't even can't require any pre-approval of curriculum, can't monitor how the children are doing, require assessments periodically if the parent says, my religion tells me that this is none of your business. But the court has not actually said that, right? The court has said repeatedly that states may reasonably regulate education in any form to make sure that the kids are doing okay. And if that were the regime that the states actually required, and some states do mandate for all homeschoolers or for most homeschoolers some demonstration of academic progress, but you could do that, right? If you really think this is best for your children, you can show how they're learning to read and they're acquiring thinking skills by learning about other cultures and learning different languages. You shouldn't have any difficulty.
We did homeschool. We did not use the religious exemption because we felt like it was kind of our duty as parents to, no matter what our religion was or what our faith was, to be responsible for the education of our kids. We kind of watched people send their kids off to school for babysitting, and that was distressing, and we felt like not good for the kids. So when we were able to teach our kids to read at age 4 and 5, we were so motivated and excited. This is fun, this is exciting, and by the way, we can, disciple them in Christianity and in their faith. So for us, it made more sense to have the opportunity to be responsible. You asked, how do we treat parental rights? Do we treat them as parental duties? There's a thing we need to know, and law students should especially know this about parental rights, is that they were founded in 2 cases in 1923 and 1925. Parents have the right to direct the upbringing of their children. They were really based in something called substantive due process. And that's kind of code for, well, we know it's there, but we don't know where it came from, and it's not in the Constitution. So the problem with that is when a court finds something with substantive due process, the court can give it and the court can take it away. So unless you understand that your duties and rights, if you want to call them that, as parents are really from God, you're responsible before God. So we call that an inalienable right. I still don't like the rights language. I guess I would say I'd say parental responsibility. And that goes for whether it's, assisted reproduction, no matter how we're doing it. Like Jim said, they can be thoughtful or they can be terrible, like Arina said. So it's that responsibility. And we've lost that sense of personal responsibility in our culture that leads us to this my autonomy thing, which is what we've been discussing all day. If we could change that culture, make our culture good again by wanting to be personally responsible and responsible for your neighbor and what's good for your neighbor, which includes your child, your spouse, the person down the street, the person being harmed by the person down the street. That could change our culture dramatically. Now, I don't know, does that mean a revival? Could be. In fact, revivals have happened and brought that about. At the same time, I don't think you must be a Christian to see yourself as a responsible person, but I think Jesus Christ makes me want to be more responsible. So for you, Tim, as a parent, I guess are you a parent yet? Oh, good. Well, you got lots of time to think about it. We, too, took lots of time to think about it, and it was well worth it. And you can talk to our kids about how they felt about being homeschooled. Find out who's really the experts on it, the kids, not the parents. Great question.
I'm not a parent either, but I do wonder about that as well, because parents are the first educators of their children, and they should be. And if the government were to tell me that I can't homeschool or I can't educate my children in a certain way, and if the government were to say something about, well, this is in the best interest of them, as they tried in California, well, that's where you say no. That's where you stand up for your own rights and duties as a parent.
Jim, do you want to comment on that? Okay. Another question? Right back there.
Good afternoon. Good afternoon. My name is Brianna. I am a first-year counseling student. So hello, all you law students.
Welcome.
So I had a question, because as I go out and about in the world, I encounter a lot of things about children as property and being used as a way to get resources. In some cases, in an extreme case, a woman had 11 children. To get more refund and more allocation from different people. I just want to see your thoughts about that, like children being used as property in an economic sense to gain and be exploited without the consideration of that being a continuous life that you must be responsible for. And I guess as well as child rearing, I guess, or understanding parenting as a duty instead of an entitlement to more things or government assistance.
Good question.
Let me start this one because I just wrote an article about this, and what you're talking about is having children to gain more public benefits. Okay, so Children that are the objects of gaining more public benefits have less of an investment in their lives from their parents. That investment is called human capital. When we invest in people's lives, we create human capital. That's what education does for all of you students sitting here. It makes you more valuable. You have something of worth that cannot be quantified because of your education, because of who you are, because of how you use that education. When parents rely on public benefits, they have less of an incentive to invest in their children. So the result naturally is those children get less education. They don't get as good of education as a parent that maybe has invested, especially a parent that has used assisted reproduction techniques and invested $50,000 in their beginnings. That parent is going to be more likely to invest in tuition money for their education from the beginning. But a parent that hasn't made that investment but has actually had them to get more money is less likely to help develop that child's human capital. What happens in a generation? We have a bunch of children that have been not invested in and cannot be contributors like the child that was invested in by their parents. So this is kind of an economic problem. And you can see how a certain way that we look at economics in parenthood can really affect a nation's strength or its weakness. So just kind of a background on that.
I'll just add more of from an ethical perspective, that children cannot, no person can be a means to an end. And in this way, they're being used for a different end and not for themselves. And even having children, and this is where I see the objectification and the commodification of children, that whatever means necessary to create to create children and to have them are being used. But if we focus on the language of gift and not entitlement, then we see them as ends in themselves. And I think that is the healthy, proper way to view any human relationship.
Jim, any comments? Another question? Got a few more minutes. Sandra?
I have two quick questions. First, the fact that children have rights was stated. Do children have a right to privacy? And when the state, and in addition to that, if a child desires to be in a harmful relationship, does the children have the right to be in that relationship? And then my second point, I love the idea of duties, but do we criminalize parents or other actors when they don't fulfill those duties?
Good questions. Go ahead, Jim.
It's important to recognize that rights can come in two varieties, protecting different types of things. You can have choice-protecting rights that entitle you to whatever you want, which could include a bad relationship, and you see this all the time with children in foster care who are hoping that their parents will get off of drugs and otherwise get rehabilitated. They want to go back home no matter what, right? And so if you ascribe a choice-protecting right to them, they could harm themselves. But there's another conception of rights, which is interest-protecting and can be exercised by other people. And that's mostly what I talk about when I'm talking about children's rights, is rights they have to protections of their interests as exercised by other people, by caregivers, and perhaps jointly by different decision makers. And so they might have privacy rights that are interest-protecting rather than choice-protecting. They might have rights in relationships that are interest-protecting and not choice-protecting. With the older children, with adolescents, we usually do ascribe choice-protecting rights with respect to relationships. They can refuse an adoption, they can choose which divorced parent they primarily reside with, and so forth.
I was going to answer your second question. It's great. So do we criminalize a breach of duties? I think was your second question, right? In some situations, yes, we do. Okay, a breach of a duty to keep a child safe by a parent who harms their child by hitting them, doing some kind of violence against them, yes, we do criminalize that. We can be charged, convicted, and sentenced. We also criminalize a breach of a duty to support. Non-support of a child can be criminalized to an extent of incarceration, can occur for non-payment of child support. But usually what happens with a breach of duties is a loss of rights that correspond with those duties. like a termination of parental rights when a parent has been continually abusive of a child over a long period of time, or a parent has continually abused substances and been negligent toward their child, neglectful toward their child. So the criminalizing is part of it, but a loss of duties is the other part. Loss of rights is the other part.
Any comments, Arina?
No, I would say the same thing. And of course, in adoption cases, the parents hand over, whether it's because they could not themselves, whether it's abuse or neglect, they could not fulfill their duties, or because whether someone just had a baby and she's 15 and she can't give the child the proper care, they relinquish those rights. But I think that the loss of duties towards the child comes when there's neglect or abuse.
One more question? Go ahead in the back.
Thanks. Hi. I was wondering, for those of you who are pro-life, a lot of times arguments I encounter are that it's better for children to never be born than to live a life in foster care, or it's better for a child to have never been born than to live life with Down syndrome. Is that a vulnerability of the best interest framework, or are there effective counter-arguments to those arguments?
I guess you mean me, huh? I would argue that there's a problem with that because it assumes that no life is better than life without a particular quality of life. So it takes a theoretical position that you have to have quality of life, not sanctity of life. And that's where the problem begins. So I think the rest of your question asks if the best interest can protect that. I guess it could. I guess a rights framework might protect that to a certain extent as well. But see, the essence of the best interest framework is that it lays duties on all the parties that are responsible for what happens to a child. And those duties laid on those parties, whether they be parents or state or other actors appointed as agents for the child, that means that the child is going to have protection, not for a quality of life per se, but the essence of being able to live at the outset. I think if we were to ask somebody that had a Down syndrome child, wouldn't it be better if you didn't have that child? They would say, absolutely not. This Down syndrome child has a totally different quality of life than I have, but they've enriched my life so much. Every parent I've ever met with Down syndrome child. Now, they don't downplay the difficulties either. And the same is true of, I think Jim mentioned, us when we're asleep. We are completely inadequate. Does that mean we lose our rights when we are inadequate and our quality of life is different? No, I mean, that's absurd because of the moral status the person has. So I think you started from a pro-life premise and because you value life for the sanctity of it, not because of the quality of it. And that's a very dangerous thing. The best interest of a child approach protects the status of that, the moral status of that life, not just the quality. Great question.
I have a few comments too. In addition, this actually came up in my thinking about it as well, about cases where children are conceived in rape or in a single parent home or some situation that is not ideal for their full flourishing. And once the child is conceived, that child has the right to life, and there is nothing that can take the value of that life away from the child. So I think coming from that perspective, we would support that life. I think what we have to think about is in the case before conception happens, and I think this is what the one Professor Kohm was considering, that we should help, the state should have a part in helping parents to be fit parents and to prepare themselves so that they can serve their children best. And in that way, they can be protected even before conception. But once conception happens, every life is welcome. But again, the ends don't justify the means. So we really have to think, is IVF or is cloning or is surrogacy, is that in the best interest of children to begin with? We should have laws prohibiting these things if from the beginning those are not in the best interests of children, so that we're not just thinking about best interests once children are conceived, but even before that, to protect children from those kinds of situations.
And that goes against the life is not as good as the quality of life. I would say that some life is better than no life at all. And what's that? Descartes, I think, therefore I am. There's this thing about life that is just so important and essential that the problem of IVF may seem scary and what are we doing, but gosh, it's something that's not a surprise to God. In fact, He created it. So, and this first happened to me, Arina, when a student came up to me in family law, and we had just done the assisted reproduction section. This was about 7 or 8 years ago. She came up to me and said, I just want you to know that I was a test tube baby. And there she is standing there, 23-year-old law student. And I had to rethink what I thought. I had that knee-jerk reaction, oh no, never do that. But there's so many, now I have probably had like 12 students that have been the result of their parents doing assisted reproduction. It's clear God wanted them in existence. So doing it responsibly and thoughtfully, and gosh, God is the one in control of who gets to be born, who doesn't. And He takes care of even those that do not get to be born. So I guess I want to say, if you have a knee-jerk reaction, just be careful of that. Rethink, be thoughtful about it. Realize that none of this escapes God's will. He's going to take care of all of those children that result from even the Craigslist child. He has a plan for that child, doesn't He? How could He not? He is totally in control. So if we think differently, we're kind of missing something about our own insignificance in light of the grand plan. I'm sure you didn't mean that.
Can I actually respond to that?
Yeah.
So what I mean is, if children are created in this way, obviously they deserve every single bit of the respect of anyone conceived in any way. What I'm saying is that we have to think before these children are conceived if this is in their best interest to begin with, because children do deserve to be born and conceived from the marital union, but obviously if children result from, I also know people who have been conceived in various ways, and once they're there, they have all the rights and deserve all the respect of every single one of us.
A good way to think of that is lawyers who have clients that are doing assisted reproductive technology. Often what happens is there's a removal of eggs and sperm and a fertilization of, say, 9 or 10 embryos, because they all may not make it through gestation, which is why some people have a lot of frozen embryos left over. They may have 3 or 4 or 7 left over. If you view yourself as a parent responsible for those 7 leftover embryos, you're much less likely to destroy them, to give them to research, or to let them just decay and have a demise, because you feel responsible for their parenthood. And if we can help our clients to think like that too, rather than, I'm just going to create as many eggs as I can just so I can get the 3 kids I really want. But if I see myself as a parent of those 10 embryos, I'm going to be a lot more careful and maybe say, do we have to fertilize all the eggs with the sperm? Can we freeze the eggs separate from the sperm? Do you see what I'm saying? To be thoughtful about it and to realize we're parents of embryos. And I think you would agree with that as well, that, the responsible parent is responsible for all the embryos they create, not just the ones they gestate. And a responsible parent is going to say, I'm glad there's research, but I'm not sure, I don't want it to be on that child that really I'm responsible for, that I've allowed to be created and frozen.
And I come from the Catholic perspective, so reproductive technologies that remove the conception of a child from the marital act between a husband and wife is not accepted in the Catholic Church, because it removes, it deprives the child of the right to be the fruit of the loving union of the 2 parents, and also because of it takes away the actual marital union. There is no sex. There is no procreation taking place and also the possibility, since you are removing a number of eggs, fertilizing them. A lot of children who are the result of IVF have siblings who have died as a result. So for them to be there, they've had siblings either who were implanted with them who died, or they have siblings that are now frozen and kind of in limbo. So it creates a lot of different difficulties when you remove that aspect of it, but that's the perspective I'm coming from.
Okay, we need to end there. Let's thank our panelists one more time.
Thank you, guys.